All rise. Florida District Court of Appeal, First District is now in session. All those with cause to plead, draw nigh, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We're very happy to be back in Jacksonville again, where we treated well over here. We have 4 cases on the docket this morning. We're going to take them in the order that they appear. After the second case, we are going to take about a 10-minute break. I apologize since we're not at home. We usually offer coffee at the break. The federal government must be late on dollars. We couldn't get any coffee for you this morning. So we're just going to proceed. Are both sides ready on the first case?
Yes, Your Honor.
Counsel may proceed.
Good morning, Michael Lindell for Bassam Atallah, the appellant. I would like to reserve 5 minutes.
Okay, you have a clock in front of you. I'll try to remind you.
Very good. This bitter family dispute was settled, fortunately. And we only have one issue remaining for the court. And that is whether any interest is payable by reason of the fact that the settlement payment was delayed until August of 2008. The agreement was reached September 2006. We maintained the deadline was March 2007. My opponent maintains there was essentially no deadline until the appellee, Marwan Atallah, found a deal that he was satisfied with and sold a valuable piece of commercial property located at the corner of 103rd Street and Blanding Boulevard, which for people familiar with Jacksonville know is a very busy intersection. It's what we call Blanding property, and it's now the site of a CVS pharmacy, which ultimately purchased the property.
I understand your argument that if money was due, then you were entitled to interest from the date it was due. Tell me why, though, it's not a factual finding made by the trial court that the 6 months only applied to listing the property. Wasn't there competent substantial evidence to support that? If you say the agreement's ambiguous, and then you have the testimony of the appellee here, why isn't there CSE to support that?
Well, that was not an argument that was made so much below as has been made on appeal. The argument below was really we did everything we could to sell the property. The argument now on appeal is immediately listed for sale and maximum of 6 months are relating to the same event.
But didn't the appellee testify that, in fact, that he felt he only had to list the property? And why isn't that sufficient to raise that issue in the trial court?
Well, it was very, his testimony was difficult. If you read the full transcript, Your Honor, he backed off from that testimony, and he agreed that no, it wasn't just listing, it had to do with list pendants and other matters, and immediately didn't just modify listing. And at the end of the day, if you read the whole transcript, he agreed that it took 6 months to find a buyer. And that was his terms. But I really don't think you need to get there, Judge Wolf, because really, I think a reasonable construction of the contract, which is the function of this court, can only result in one interpretation. If you're going to give effect to all the terms...
Help me there before you get there.
Sure.
You're going to argue parole evidence here and what the intent of the parties was. But, and it wasn't really argued a lot in the brief, but it seems to me that the term maximum of 6 months is immediately after the language saying immediately listed for sale. So a reasonable construction of the English language, wouldn't that 6 months apply to the listing just based on the language of the contract? You understand my question?
Oh, I understand the argument of the appellee in this case, and I know that is their argument. If you look at the actual text, and I don't think you need to get a parole evidence, but again, I don't think the parole evidence saves the appellee here. You look at paragraph 1, and this is in the statement of facts, page 3 of the appellant's brief. Paragraph 1 sets forth the obligation to pay the total principal sum of $400,000. Paragraph 2 talks about how it's going to be paid. $10,000 within 30 days, the Blanding property immediately listed for sale, the balance of the $400,000 payable upon sale, maximum of 6 months. Judge Wolf, I submit the only reasonable construction giving effect to all those terms is essentially what I just laid out here. All parties agree this 6 months term was a hotly negotiated item late on the night of September 18. It makes no sense for the parties to be negotiating late into the night of September 18 about 6 months to list the property when they already had put in there immediately listed for sale.
Who drew up the agreement and what were the circumstances that night?
Not pretty, I know, Judge Kahn, the agreement. When you look at the overall document.
What had been going on that day before they drew up the agreement?
We tried the case the first day of the trial in front of Judge Fryfield. We resolved the threshold issue whether my client was a shareholder. Then we negotiated with all the family members and relatives until midnight. And Jaguars game was going on, and we could hear that going on. And Jeff Stout was great. He was my opposing counsel. We hung in there and we put together a deal. I was the scrivener. Quite honestly, it's my handwriting. I told Mr. Gressley that beforehand, not to use that against me, but Jeff Stout was right there, and I think we're all collaborating on this. And I understand the argument, Judge Wolf, but I would just say it doesn't fit the context of that night. I don't think it fits the grammatical logic of the document, and I think it gives an unnatural type of meaning to immediately equating 6 months.
Well, does it really, though, when you've got the sort of complex issues of environmental concerns, plus, well, for instance, a stranger reading this document, at least this paragraph, might not know how many properties they are, certainly would not know the condition of the properties. I understand your argument that immediately has sort of a meaning that we all can grasp, but perhaps in this context, 6 months is not inconsistent with immediately.
Well, as far as listing the property.
But counsel, is there, refresh my memory, what's the evidence in the record with respect to this Blanding's obligation to borrow money or to come out of pocket with $190,000 after 6 months? Because isn't that the other side? Wouldn't Blanding just have to go borrow money or come out of pocket for $390,000 if the property didn't sell, based on your reading of that provision?
Right, and we're not, and I agree with Judge Van Orlo, there's nothing in the record suggesting that is in the document, or that is just simply parties. We maintain, in order to get the deal done, there had to be a deadline for payment. We were not going to be open-ended that whenever he found the deal that he liked.
But what happened after 6 months when there's no deal? I mean, the document doesn't say, and Blanding has to go borrow money. The document would simply say that the settlement is off. We start all over again and renegotiate. I mean, where are the parties left with your 6 months interpretation?
Well, going back again, just in Norway, paragraph 1 says, will pay the principal sum. Number 2, will be paid the following manner. I mean, I think reading on those 2 paragraphs in context, maximum of 6 months is, it doesn't just say where Marwan is going to get the funds if it doesn't sell, but again, he is going to pay, and obviously we could talk about, well, where do people normally get funds if they don't get it out of this discrete property? They either borrow against it or they go borrow somewhere else. But that was his deal, and I mean, that was the deal to end a very complicated global family business dispute. And there are no real, and I know it's difficult because there are no findings in the order per se, as far as any kind of.
Didn't the trial judge implicitly rule on that? The argument was made to the trial judge.
The judge, really the argument, Judge Wolf, the argument, if you read the transcript, was primarily, Judge, we did all these things, we went out and listed the property, we had 3 or 4 contracts, one of them, it got extended, the first one forever, and then it fell through, we got another contract, and we did our best to sell the property. We don't come here today just because we're trying to create an issue about that. We're just saying under Argonaut that's immaterial because we're not here blaming anybody. We're not here on a fault theory. We're here simply on a loss theory under Argonaut. Like Nielsen Miller, I think the post-maturity interest is something that we say is applied if the court agrees that these parties contemplated that there was some time frame, maximum time frame for their receiving payment. Otherwise, the absurd result is Marwan controls all of the terms of the sale. The property's in his name. He goes and lists it. As long as it's listed, he can take it till kingdom come to sell the thing and frustrate the entire agreement. I don't think that's the proper construction of the agreement. There was a deadline.
But why would that be in his interest? I mean, it seems to me the evidence here is that fairly quickly after the property sold, you moved on for disbursement. I mean, there was not much delay. He wasn't holding on to the money and making interest on his own and frustrating it that way.
After the property was actually closed, we're not faulting anything about the judge. Judge Stout, I mean, there was great cooperation in this case between householders, but they always knew.
Well, you said there's
They
no
always knew that we wanted interest. We always talked about that after the settlement. We talked about it on the phone. There's testimony in the record that, you know, there's a lot of testimony about that. If y'all are,
your argument, though, that just by only having the obligation to list is no real obligation on the party, don't you have to read this in context and say, if you have an obligation to list, you have to list at a reasonable price, and you will not refuse any reasonable offer? Isn't that read into the agreement? So isn't that, even if we read it to say the listing only had to take place in 6 months, wasn't the applicant also bound to take some reasonable action in this case? Because it seems to me you're arguing that.
well, my counter to that is they always knew interest was an issue. We demanded that. They had full control. They certainly could include it in their deal enough to cover that cost. At the end of the day, they control that issue.
Okay, you're down 4 minutes.
Okay, thank you.
May it please the court, Bill Wrestling on behalf of Marwan Atallah, the appellee. I get nervous when I say there's no appellate issue. Presented your questions demonstrate clearly that you understand the order under review.
Well, tell me specifically, how do we know the trial court ruled on the specific issue that seems to be the crux of the case here?
I'm getting ready to tell you.
Okay, thank you.
The order under review was entered on Mr. Lindell's motion to enforce the settlement agreement. Mr. Lindell's opening statement, quote, "Here we are today, evidentiary hearing." First page, on page 14, his client testifies as to what the settlement agreement meant as to the 6 months. My client on testimony, now these two folks, brothers, are not native English speakers, so reading the transcript you can get a sense of the wording. His counsel asked him about the 6 months provision. This is on page 34 of the transcript. All right, with regard to the sale of property, did you have any expectation that the Blanding Chevron could be sold to a third party to a buyer within 6 months? My client's response was, I'm not going to say just no, no way. And he goes on to talk about the fact that it's a gas station that it's going to take at least a year to get it sold. And then the important part of this, for purposes of what the ruling was, based on the fact that the parties unequivocally presented this case to Judge Fryfield as a parole evidence issue because the 6 month provision was ambiguous. It was not clear on its face what that meant. My client's testimony was directly contrary to the plaintiff's testimony, which was, I wanted to have a chance to sell this myself because I had other people that were interested. And on page 35, he explicitly says, I wanted to save brokerage fees. That's why we negotiated the 6 months for me to be able to try to sell it. At the end of 6 months at the most, we listed with a broker. Significantly, that was in direct conflict with the other side's testimony, and Judge Fryfield's reading this agreement, understanding the actual agreement itself is not clear on this issue, and he makes a ruling based on the evidence before him. There is no appellate issue unless you want to say that one of these witnesses was not competent to testify. The reality was that there was an agreement entered into within 6 months, but because of the regulatory issues that had to go into the sale of the gas station, and everyone knew that, it took 20 months to get it sold on the third contract. The reality, Your Honors, is that this was a parole evidence issue. It was tried explicitly as a parole evidence issue. And all of the arguments that are being made now is, well, as a matter of law, this contract can't mean that. That's an issue that should have been raised to Judge Fifield, not requesting an evidentiary hearing, not moving on the grounds that this testimony was needed to explain this ambiguous provision. The long and short, Judge, is that if you ask the judge to rule on the evidence, to put meaning to an ambiguous phrase in the contract, you cannot or should not be able to show up in an appellate court and say, well, as a matter of law, the judge made an error in his interpretation, because his interpretation was based on conflicting evidence. It was at least as consistent with what these parties were trying to do to globally solve a family dispute, and it makes complete sense. If there had been an agreement that my client was obligated to sell, as in turn over title and get funds for a gas station in a maximum of 6 months, he would have been crazy to try to do such a thing, but it would have obligated him to go out and borrow money to pay this amount of money. The reality is that there was no testimony except the appellant's testimony that was going to happen. And he didn't say, we had an agreement that he was going to go borrow money. He just said, I was supposed to get my money in 6 months. So the law holds and has forever that the contract, interpretation of the contract does not require the parties meaning the same thing. It requires them saying the same thing. And in this agreement, you can't read it and make a definitive interpretation as a matter of law as what it means. Mr. Lindell understood that when he stood up in front of Judge Fifield and said, we're here for an evidentiary hearing, and proceeded to put on his client and testify about what this meant. My trial lawyer did the same thing, and the judge determined that, wait a minute, these parties couldn't have meant that they were going to get this sold and paid the plaintiff within 6 months. Entered the order under review, holding that the parties agreed as to the dispersal of funds, which were in Mr. Lindell's account the whole time, so at least our foundation made some interest on this one. Ended up doing exactly what the parties asked, which is enforce the settlement agreement as he interpreted it based on the evidence. Finally, I filed.
But Mr. Grassley, what the trial court did do is address the issue that we're now here addressing, except maybe implicitly.
Absolutely implicitly. He rejected the claim for prejudgment interest, and he found no breach.
But did not say that.
No, he did not explicitly say that. But what was asked was disperse the funds that are being held in Mr. Lindell's trust account and include interest on those funds because we were supposed to have that money within 6 months of the agreement. I filed yesterday a notice of supplemental authority. Mr. Lindell got it. I confirmed that. Just for the simple proposition that there is no interest due unless there's a breach. I mean, the Argonaut case is black letter law, and there's really no argument about what it stands for. But I found the case finally, out of the second. It is.
But you would concede that if he was required to sell the property in 6 months, then there would be entitled interest. If Judge Fifield had interpreted this contract to say the property had to be sold in 6 months, you would concede that they're entitled to interest.
I would be here arguing that that was an absurd interpretation. But if he had believed the plaintiff rather than my client, that there was such an implicit agreement, then and without this court saying that's absurd, then yes, if there was a breach, and that's the real fundamental issue here. There was no finding of a breach of any agreement. There was no finding that the funds due the plaintiff were due as of a prior date. And that's this. I'm sorry, did I interrupt you? The supplemental authority I filed yesterday is a case called Paoli, P-A-O-L-I, at the second. And it's real simple. We reversed a portion of the amended counterclaim that granted plaintiffs prejudgment interest. The general rules of prejudgment interest is allowed for actions based on contract from the date the debt is due. In this case, however, the breach of contract was dismissed and not refiled. There was no breach of the settlement agreement here. There was no date on which you could say plaintiff was wrongfully deprived of the use of their funds. And I don't mean wrongfully in some kind of moral sense, but legally. When a contract action, you get prejudgment interest when there's a breach as of a date certain. You're entitled to interest from that date. There was no breach here, never. My client performed the settlement agreement, got the property sold. Funds went into Mr. Lindell's trust account. Mr. Lindell's client all along screamed, I want interest. My client had to file a motion to make him dissolve the list pendant so they could sell the property to CBS because he was trying to extort the interest payment then. And Judge Fifield listened to this, considered the agreement, and said, that makes no sense to me based on what I'm hearing from the two witnesses. So this is a competent substantial evidence case that's claimed that the contract should be interpreted as a matter of law was waived by not raising that in front of Judge Fifield and instead proceeding, as both parties did, on the grounds that this was ambiguous and parole evidence was needed. Thank you, Your Honors.
Judge Wolf, I would like to rephrase the issue as not one whether the agreement required sale of the property within 6 months. I just want to make sure people understand, we're not arguing that it did. We're arguing that it required payment within 6 months, whether the property sold or not.
Okay.
Really, I mean, the parties realize,
I stand corrected.
I mean, the parties realize that, you know, it might sell, I mean, we can all give what we know about real estate, but I mean, part of the negotiations, I mean, there was hope that it would sell sooner than 6 months, but in any event, if it sold sooner than 6 months, payment would be made then. But the 6 months had to do with the deadline for when the balance, the $390,000, would be paid to my client. And we submit that is a function of this court to construe the agreement. Now, yes, Mr. Russell's right. I mean, we brought in 3 of the brothers who were there that night and one of the other witnesses who were there that night because this had been such a contentious issue and we were trying to give Judge Fryfield some context within which this agreement was negotiated because we realized it's not a pretty agreement. It was not an agreement where we all had time to tidy it up and address everything possible. And I think one thing that probably gave Judge Fryfield some concern was the agreement itself did not speak to the fact that one party would pay the other interest if the deadline was not met. And that's the Nielsen-Miller case, and that gave some trouble to the trial court there as well, where the instrument did not, it was silent on the payment of any interest during the, up until maturity, and it was silent on any obligation to pay interest after maturity. But my opponent and I agree that the law in Florida is, under a scenario, if there is a deadline post-maturity, we're entitled to interest at the legal rate. We just submit here that while I know it's very tempting to affirm based on the arguments that have been made, I would ask the court to honor its role as the one to construe the agreement and to give reasonable effect to all its terms and to give a reasonable construction that comports with
I know this was a judge-heard case in the context of a hearing, but did you call to the trial judge's attention that there had not been a ruling on what now seems to be this positive question, the deadline for payment, by way of a motion for rehearing or anything like that?
No, I did not.
Because it seems to me if you have a remedy here, I don't know how your remedy could be more than requiring Judge Fryfield, whoever's sitting in that division, to make that determination. I don't know how we could do more than that as an appellate court.
Was there a motion for fees here? Formal motion?
Fees. A motion.
A motion for attorney's fees under the agreement.
The agreement did not, the settlement agreement didn't really have an attorney fee provision, as I recall, in it. I think in our motion to enforce the settlement agreement, there was sort of a half-hearted effort. We brought up the fact that not only did we have delays, but we had to go back to court a couple of times trying to get things moving along. And there was some reference in there, you'll see a reference in the transcript and in our appendix that there was some dollar amount of what fees we'd incurred post-settlement. It was not a huge amount, but there was some reference to that.
Your time's run, thank you.
Thank you.